So I'm gonna need to keep this thing moving.
Are you gonna bang the
Very true.
the hammer? Do we?
The gavel.
Is there a?
Here we go.
Hammer's called gavel. Hey Legal Eagles, let's think like a lawyer. Today we are covering the highly requested episode of It's Always Sunny in Philadelphia, McPoyle versus Ponderosa, the trial of the century. This is particularly exciting for me because I think by the end of this episode we will finally solve the mystery of why people keep asking me if I know anything about bird law. I have no idea what that means, but I think it originates in this episode of It's Always Sunny. So let's dig in and find out. Remember to comment in the form of an objection, which I will either sustain or overrule. And while you're there, let me know what movie or TV show I should do next. And of course, stick around until the end when I give this episode of It's Always Sunny in Philadelphia a grade for legal realism. So without further ado, let's dig into McPoyle versus Ponderosa, the trial of the century.
Yeah, Bill, you gotta relax, okay? Uncle Jack and I, we got this case. All right, now listen to me. Liam McPoyle's gonna come at you hard, all right? But I've done my research. I got something with this bird theory that's gonna blow.
All right, there's the birds.
I'm well versed in bird law.
Pondy, keep your eye on the prize. This goes well. It's party time.
What is that? Is that drugs, Frank?
Yeah.
No, dude, I need you keeping him clean, all right? That's why you're here.
I gotta have the drugs here to keep them clean.
Well, that doesn't make sense.
That does not make sense. Okay, so within the first 30 seconds of this episode, someone has brought a bag full of drugs into court. Somehow, I'm going to go out on a limb and say that this is not going to be the most accurate legal drama I have ever reviewed. Don't bring drugs into court. Bad idea. Very likely to get searched, very likely to be arrested. Don't bring drugs to court.
Come on, man, everybody's got a thing. Don't leave me out. Frank's got a thing, Dee's got a thing, Dennis has got a thing.
Dennis has a thing. What are you talking about?
Oh,
What are you doing here?
There's got to be a way to get this court to let me out of my alimony payments. I mean, have you guys seen Maureen? Well, the woman has gone almost full cat.
So not only would that distract from his case, but there is absolutely no way that an unrelated party can go in and request a family law matter be thrown on the docket of the Superior Court. Family law courts and the Superior Courts are two completely separate entities. The family law courts handle things like divorces and child support. They do not handle your general jurisdiction civil lawsuits. That's what the Superior Court is for. The Superior Court is where you'll end up if you have a civil lawsuit. They have different judges and they have completely different sets of laws that they are going to apply on a daily basis. And you can't just show up in court one day and ask that something be thrown on the docket because your ex-wife is pretending to be a cat. God.
You'll be dealing with me today.
And you'll be dealing with me today. Jack Kelly, lawyer. Good to see you again.
Are those fake hands?
No?
What is with the fake hands?
Fake hands?
You know what? Good luck with all of that today.
So in reality, before you even get close to a courtroom, you're gonna go through a process called discovery. Discovery is the process by which you get information from the other side, and the other side gets information from you. You are allowed to request relevant documents, you're allowed to ask the other side questions, and you are allowed to question them in person under oath through depositions. So before you ever get close to a courtroom, you're going to have to interact with the other side, whether you want to or not. Many, many times through discovery, there is no longer any trial by sandbagging. You have to turn over relevant information to the other side, and the other side has to turn over relevant information to you. So you would never just introduce yourself for the first time at trial. This episode appears to have skipped through one of the largest portions of a civil lawsuit.
Okay, we have McPoyle versus Ponderosa, seeking damages for the loss of an eye in the form of a one-time payment to the sum of $200. Are the plaintiffs present?
Okay, the judge would never, ever let it proceed to trial. That is such a small amount. Number one, it should be in small claims court, not the general jurisdiction of the Superior Court, which can take any amount in controversy up to millions or billions of dollars. It's funny that the judge here has made a snide remark because it's not realistic for a $200 matter to go forward. It's crazy.
Your Honor, and if I may, Charlie Kelly, co-counsel, background in bird law.
Nephew.
Yeah, but excited to be in the People's Court and a big fan of black judges, too. Stop touching me.
Oh boy. Okay, so I don't think Charlie Kelly here has a law degree. I don't think he has passed the bar. He cannot introduce himself as a lawyer here, and I think that that is a problem for his co-counsel, who actually is a lawyer. I think because of the representation as a lawyer, that's a potential grounds for sanctions by the bar here, both for Charlie, but also the co-counsel. This is not normal at all.
Okay. Look, all I need are the facts to this case. I have a very long day ahead of me, so I'm gonna need to keep this thing moving.
Are you gonna bang the
Very true.
the hammer?
The gavel.
Is there a?
Here we go.
Hammer's called the gavel.
My client is odd. You might even refer to his family as very creepy. But they are saints compared to Bill Ponderosa and the sordid lot of degenerates he associates with. Terrible people who ruin lives. Ruined mine, cost my client his marriage. Ruined my first, now my second one is teetering.
You're not allowed to bring in character evidence, except under very specific circumstances, none of which are present here. Character evidence is where you're saying that someone has a certain character for acting in a certain way, and therefore they likely acted in that way that is in conformity with their character on a specific instance. Courts, I think, rightfully look down on that kind of tenuous, specious argument, and they don't allow that to come in except under very rare circumstances. And additionally, in an opening statement, you are not supposed to be arguing, which is what this attorney is doing. So despite claiming to be a very good lawyer, he's not doing a great job so far. It looks like he's allowing his personal bias to enter into his opening statement.
Your Honor, I'll keep it brief. I just have 3 things to say. 1, Liam McPoyle has a history of lying. 2,
That's character evidence.
my client is a loving family man. And 3,
More character evidence.
he is innocent.
Oh boy. Okay, so that lawyer's opening statement was actually very similar to the other lawyer's opening statement. It is filled with character evidence. Sometimes you can bring in someone's character for truthfulness. That is slightly different than normal character evidence, but still, that opening statement is number 1, terrible, number 2, strange because he's wearing these giant hands for some reason, and number 3, this lawyer didn't explain or provide any facts as to why his client is innocent of the things that are being alleged against him. And I'm not even sure what's going on here other than claiming that there was a loss of the use of one eye. But neither of the lawyers here have done a very good job in their opening statements at all. Are they ever going to explain why he's wearing giant hands?
I'm gonna stop you right now. Are you just gonna talk about your hands for a while?
No, Your Honor. No more questions for the witness.
Deandra, here is the statement that you gave to police.
Okay, the order of this questioning is totally backwards. The plaintiff bears the burden, and so they have to call their witnesses first, and then when you call a witness, you question that witness first, you then get a cross-examination, and then under some circumstances, you get a redirect examination of the witness. It is not at all clear that the plaintiff has done the first round of questioning. I think for dramatic effect, they switched the order of the questioning.
Bill did it. That drug addict is out of his mind. I'll testify to that. And I swear on my mother's grave that Bill spiked that milk, no doubt about it. He's guilty, guilty, guilty.
So here, he doesn't actually get an answer from the witness. So there wasn't actually any testimony that was elicited. Not that there's a jury listening, but the judge may actually care what's on the record and what is not on the record. And all he's done here is asked a question and elicited no response from the witness, and therefore he hasn't gotten any evidence that will help him in this trial. Now, this document may also be hearsay. It sounds like it might have been a sworn statement to police, so under some circumstances that might not be hearsay. Remember that hearsay is an out-of-court statement used to prove the truth of the matter asserted. Here he is definitely using it for the truth of the matter asserted, that Bill Ponderosa is guilty or liable for whatever he's being accused of. But the main problem here is that he hasn't gotten an answer from the witness, and he hasn't entered this document into evidence. So there's no evidence to talk about right now.
I'm sorry, what did you say?
He spiked it, and then he tried to bribe me.
No further questions, Your Honor.
Ma'am, Do you know what perjury is?
If you would like to know more about what constitutes perjury or defamation, check out my episodes of Real Law Review, which I'll link down below. I think Dee would have benefited from seeing some of those.
You know, I feel like I'm not being utilized properly.
Well, that's because you don't have anything, so you're not being utilized at all.
Yeah, but what if I get to deliver the bombshell?
Oh. What bombshell?
You guys don't have a bombshell? Oh my God, every good case needs a bombshell. Oh, Jesus Christ. Without it, you're screwed. Okay, you know what? You know what? I'll find one for you. I'm gonna do like a hero cop Mark Furman thing, and then sort of transition into a Kato Kalin.
Yeah, I wish you would do none of it.
All right,
I wish
cool.
you'd do
I'm
none
on
of
it,
it, man.
I'm on it.
In reality, cases rarely have bombshells. That's the whole point of discovery, is not to be able to sandbag the other side or to pull out some crazy theory or fact in the middle of trial. In reality, you want the case to end as soon as possible, whether that's through settlement or through trial or through dismissal. So you don't want things to wait until the end, and in real life, you don't have bombshells. Those are disposed of a long, long time before you ever get to court.
Your Honor, nothing represents the tragic aftermath more than the dramatic transformation of this woman into...
Cat.
Excuse me?
As I transition from woman to cat, I must insist on being referred to as a cat.
Objection. She's not a cat, Your Honor.
Also, what is the relevance of this
If the witness
testimony?
wants to consider herself a cat, I will allow it. I just need to know where all this is headed. How is this relevant?
Well, it's
Thank you.
clearly relevant. The attack had a psychological impact on all the parties that evening. No further questions.
Okay, first of all, that has no relevance as to whether the person did the thing that they were accused of, which is, I guess, is spiking some milk with bath salts. And number two, they're not suing for psychological damages, so all of this testimony, whatever psychological effect it had on other people, has no bearing on this case. And whether it injured other people who are not plaintiffs here, again, not relevant to this particular case. So all of this is irrelevant.
Your Honor, do you see what's going on here? This is crazy. You know what? I'm gonna approach the bench.
No!
Can I just approach it real fast?
Absolutely not.
All right. Earlier, you referred to my ex-wife as a cat per her request. Now, surely you wouldn't force a man to pay alimony to a cat, right? So, motion to establish me not having to pay alimony anymore.
I will not allow that.
Okay. Well, so we'll pop it on the docket? We can put it at the end of the day if you want. I just want to clear it up while I got her in a courtroom.
I will not allow that either. Sit down.
All right, I mean, that was probably the right result here. There's no reason why he should have this matter heard in front of this judge in this court. None of that is related to family law. I probably don't need to tell you that people in the gallery are not allowed to make legal arguments or request relief from the court.
He totally did it. Okay, well, then I guess we will never know, ladies and gentlemen.
Uncle Jack, he just confessed.
You did?
Yes!
Yeah, Ryan stabbed Liam. I totally saw it.
Oh, my God! We won!
So you see this a lot in legal movies and TV shows. There will be one good piece of evidence that comes out on the stand, and then suddenly everyone is celebrating as if they have won the court case. This is not the end of the game. This is just the very beginning. There will be lots of other testimony, and rarely is one fact dispositive, and certainly not this particular fact.
Lion, was Ryan drinking milk at the wedding?
Of course. Everyone was.
So, who did the stabbing doesn't matter, Your Honor, because they were all still drugged on Bill Ponderosa's spiked milk, which is the point I've been trying to make the entire time. So just to be clear, you've proven my case. You lose.
Okay, a couple of things. Number one, you're not allowed to make argument in the middle of a cross-examination. This happens in movies and TV shows, but it is not realistic at all. You are allowed to ask questions. You are allowed to receive the answer from the witnesses, but you are not allowed to just turn around and start talking to the judge and talking to the other side and arguing your case.
Okay, Mr. McDonald, you recently found out some very interesting information. Care to share it with the court?
Yes. I've recently been informed that Ryan McPoyle only drinks mother's milk, which means there's no way he could have drank the milk that Bill spiked, which means he was sober when he attacked his brother, which means Bill is innocent. Case closed. Kaboom! Bombshell!
All right. Just as an attorney is not allowed to make argument during a cross-examination, neither can the witness go off and make argument. If he has evidence, great. State your testimony, state the precipient facts that you personally have witnessed, but you can't then just go on this tirade making argument about what you can infer from the different kinds of evidence. So everybody's making argument here. It's very entertaining. It is not realistic at all.
How did you come upon this information?
Oh, I banged Margaret McPoyle.
I'm curious how she told you, because Margaret is a mute.
Well, it's still hearsay either way.
I had her write it down.
All right, just because she has written this down does not make it any less hearsay. It is still an out-of-court statement used for the truth of the matter asserted that only mother's milk is consumed by the individual. Oh boy, this is so weird.
Your Honor, Mother is the name of the McPoyle family cow. The cow that provided the milk for the wedding, the milk that was drugged by Bill Ponderosa.
That mute lied to me for sex!
Bombshell diffused.
Abramowitz!
All right, so there are a lot of problems here. The lawyer is again making argument without getting testimony from the witness. You need to save your argument for the closing argument. He's getting testimony from someone sitting in the gallery. Just call her to the stand. You can have a deaf or mute person testify through an interpreter. That's a very easy thing to do. And you have to enter this picture that is being discussed into evidence. Otherwise, none of this counts at all.
This is the McPoyle family crest. On it, you will find a bird, a Pocono Swallow, to be more accurate. A very rare, very elusive bird. You'll notice its trademark unibrow, highly uncommon in most aviary circles. And my research shows that unlike your typical North American barn swallow, the Pocono swallow, if kept under the proper conditions,
what does this have to do with anything?
As 80 to even 85 years, much like a parrot or some of the more resilient coastal gulls.
Your Honor, where's this going?
I don't know, but it better lead somewhere fast.
He's gonna say all
Your Honor, I can assure you that this will be our final argument.
Well, if it's gonna help end all of this madness, I'll allow it.
I'll allow it. Again, you're not allowed to just bring in random posters into evidence. You're not allowed to make argument where there should be some testimony going on. Charlie has said that this will constitute their final argument, but the problem is 100% of what he is talking about never came out in court. So all of this is not in evidence. You're not allowed to make argument based on facts that did not come out in the trial itself. So all of this is improper, whether this is in place of testimony or whether it's in place of argument. It's all ridiculous. It doesn't seem relevant at all, and it's 100% improper.
Bye, birdie. Ready, boys and girls, because here's where it gets good. Ryan McPoyle didn't attack Liam, Royal did. And Lion was lying about Ryan attacking Liam to protect Royal from the chair, or lethal injection, or perhaps some sort of small bird guillotine. I wouldn't understand the physics of it. I'm not an executioner. I'm just the best goddamn bird lawyer in the world.
Okay, I guess that could be true. He could be the best bird lawyer in the world. That's not really a thing, but he is one of the worst trial lawyers I have ever seen. He does nothing but improperly argue at times when he should be eliciting evidence. He is relying on speculation, on facts not on the record, on hearsay, on irrelevant testimony. He tried to get evidence out of the gallery. He tried to bring in new evidence that hasn't come out during his closing arguments. He is basically breaking every rule that exists in civil procedure at this time. This is the biggest train wreck of a trial I've ever seen in my entire life. And I've seen a lot of trials. This is bad.
So bottom line, and listen up, numbnuts, because it blows a hole in your case. Birds don't drink milk.
Facts not in evidence, improper opinion.
Didn't the bailiff ask everyone to remove their hats?
That is true. Mr. McPoyle, would you please remove your hat? Mr. McPoyle, please remove your hat.
Perhaps he is too insane to understand the question. Why don't I just...
So as ridiculous as this part is, there is actually a part of the Code of Civil Procedure that does allow for a physical inspection of the other side. You have to make a motion with the court, and there are certain hurdles that you have to go through because you can imagine that people could abuse the right to physically inspect the other side or to ask the other side to get a medical examination. But there are actual provisions of the code that allow you to do that when it is relevant to the specific case. Who knew?
Your Honor, this is Mr. Belka Mayer. He's a professor of ornithology at the University of Penn. Mr. Mayer, it's safe to say you're a bit of an expert on birds, yes?
I believe you're correct.
And you would understand this Pocono Swallow quite well, wouldn't you?
Yes, I do.
Then please ask it if it attacked Liam!
Okay, I probably don't need to tell you this, but you are not allowed to conduct a second examination of a different witness while you have a first witness on the stand in the first place. You just have to excuse the first one, then call the other person back up to the stand. If you need to readdress issues with the first witness, you can call them again as a rebuttal witness or ask for a redirect. But you're not allowed to have someone sit at counsel table and ask them separate questions. He's not even under oath. This is all very, very improper.
In my 35 years on this bench, I have never seen such a mockery made of this courtroom. You people have wasted my time, you've wasted the taxpayers' time, and this justice has heard enough. I am throwing this case out. I should have done it hours ago.
Yes, you should have thrown out this case. It was ridiculous.
This court has ruled. Now I suggest that you people get the hell out of my courtroom before I put you all in jail.
Yeah. Rule number 1, never piss off the judge. Okay, now it's time to give McPoyle versus Ponderosa a grade for legal realism. So they didn't get a whole lot right. They had counsel tables and wood panels on the walls. On the other hand, you had lawyers making argument instead of asking questions. You have neither side really getting any evidence out. You have facts that were never mentioned at any point. So they basically get everything wrong. Now, I've never done this, but I think this episode of It's Always Sunny in Philadelphia deserves a flat F. I would not allow this in my court. Do you agree? Leave your objections down below and check out my other reactions over here, where, as always, I will see you in court.